screen that shows hand step?
Yes.
Okay. Let's see, Ms. Whitler, or actually, her. There it is, all right. Okay, two cases involving the same defendant. Case number 19, CR 124, and 21 CR 80. State of Ohio versus Lacey Hensley. Lacey Lynn Hensley. Ms. Hensley is appearing by Zoom from Counseling Center. Her attorney is Dennis Kirk. He is appearing by Zoom from his office. And Assistant Prosecutor King appearing by Zoom from his office. And Mr. Kirk, you and your client both agree with this matter being conducted by Zoom remotely rather than in person.
Yes, Your Honor.
All right. Now, Ms. Hensley, since you're not present in the courtroom next to your attorney, if you need to talk to him at any time, you just tell me and I'll put you into a breakout room where it'll just be you and him on the screen talking to each other. No one else will be able to hear you or see you, okay?
Okay.
All right. Now, in case number 19 CR 124, Ms. Hensley was convicted of possession of heroin, a fifth degree felony, put on community control on August 2020, and then in case number 21, CR 80, obstructing justice, and it was also put on there August 12th of 2021, was placed on community control. I'm sorry, plead guilty. And actually, I guess we're here for sentencing on that, as well as disposition of the other. So, the court did order a pre-sentence report, and each of the parties received a summary of that.
They have, Your Honor.
I have, Your Honor.
All right. Anything from the state regarding sentencing?
In the 21 CR8 case, the state would just ask that the court follow the board recommendation. And in the 19 CR 124 case, the state would ask that the defendant be continued on community control and referred to drug court. Thank you.
Sure.
Thank you, Your Honor. I would ask the court to follow state's recommendation in each case. In the right before the 21 CR 80 case was filed, my client did voluntarily go into residential treatment and then left there to come take care of this case because they recommended she do so. So in this case, she's back in treatment. All reports she's doing well and would be a good candidate for both continuation in residential treatment as well as drug court. So I would ask the court to follow those recommendations. Thank you.
All right, Ms. Hensley, anything you'd like to say? You need to unmute yourself there so you can respond. There's a little microphone with a slice through it down the right-hand corner. Or actually, left.
I got it.
All right, got it, right? Anything that you would like to say?
Yeah, I realized what I done, and I realized that I was in a mess and I needed to fix the situation. So in May, I admitted myself into residential treatment, and the last 60 days that I done in jail was a huge lesson that I had to learn. So I would greatly appreciate the opportunity to continue the treatment, and whatever my lawyer said with drug court and things like that, I think that would be good extra accountability for me to have whenever I do finish here.
All right. Well, Ms. Hensley, I believe Ms. Sturgill, you have filed her application and her acknowledgement of the conditions.
Yes, sir. It's been filed.
Okay. And what was your? I don't see your letter here. I'm sure you sent it, but your final sheet had the criteria, clinical criteria.
Yes, sir. I think she would be a good candidate for the program.
All right. Well, Ms. Hensley, I'm sure your attorney probably discussed this with you, but under the law, I don't sentence people into drug court. I accept their application, so that's why you had to fill that paperwork out. Because, I have the authority to put you on community control, regardless of whether you want to be or not. But in terms of drug court, that is a voluntary act on your part because it is a higher accountability, it is more intensive, there's more programming involved, but there's also a lot more resources that are devoted to supporting people that are serious about recovery. It focuses on recovery as opposed to simply community control, because if you are able to stay sober, then it's highly unlikely that you're going to commit another offense. Whereas the idea in community control is basically to hope the person does well enough to avoid being sent to prison. So, sobriety is not necessarily the goal in those cases. It's a hope, but it's not as intensely focused as it is in drug court. And so that's the situation that you're signing up for. That's something that you still want to do.
Yeah, absolutely.
All right, well, the court then is going to accept you and orders that you be accepted and admitted into the drug court in both cases, and you'll be required to comply with these conditions in both cases, but it's just new community control in your 20 CRA case, but you'll be complying with the same conditions in your 124 case. And that is that you must comply with all the requirements, conditions in the drug court program description, and you've had that previously and gone over with me by Mrs. Sturgill. You'll be under community control supervision of the probation department for 3 years. You'll be required to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when as directed, be truthful in all statements you make to the probation department. Must keep them informed of your residence and place of employment at all times, and not change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. A copy of that you must have it with you when you are in another state. You may not enter upon the grounds of any correctional facility or communicate with anyone who is inmate into the facility without prior written permission from your supervising officer. You're not permitted, because of your conviction in the original case, 190124, to possess, own, use, have, or purchase any firearms, ammunition, dangerous ordnance, because to do so would be a violation of federal and state law. It's also a condition you not have any of those or any other weapons of any type while you're on community control. You're not permitted to purchase, possess, use, or have in your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog, any controlled substance, drug abuse, and committing those, and you may not have any device, instrument, thing that can be used to administer those, again, unless you have a lawful prescription for either or both, and if you do, you must provide a copy of that prior to receiving it. You may not obtain medical marijuana product on the drug court docket. You're required to submit to drug testing when and as requested. You're not permitted to purchase, possess, use, or have under control any alcohol or any other type of alcoholic beverages, or may be placed in a present place where sold will be consumed, even if otherwise lawful. You're not to associate with anyone as a co-defendant in this case, or any other person as a criminal record, member of gang or a criminal group, or any person who has a past or the future. If unless you commit a criminal offense and violate these conditions, which applies to any family members, that might apply to, except those who are living with the before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type of relationship with another person without permission of your supervising officer. Must report any conviction or citation or other charge violating the law or any other type of contact with law enforcement not later than the end of the next business day after that occurs. Must provide your supervising officer with financial information records so that your ability to pay any fines, fees, costs can be reviewed. You must provide your supervising officer, if you're referred by your supervising officer or treatment team for any further evaluation or treatment, beyond that already ordered by the court, or beyond that currently is in place in your treatment program, then you must submit to that. If there's recommendations you don't go for the programming or treatment, counseling, etc., if you're enrolled in and successfully complete that. Pay the court costs of this action, make payment arrangements with the clerk. You'll comply with all the conditions I said set forth in the drug court docket, again in both cases, and comply with your treatment plan as recommended. Not what you want, but as recommended. And so if they give you the option to say, these your options, this is what we recommend, and we do, there's 3 options, you do what they recommend. You can't choose option 2 or 3. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property placed under your control where you're found at any time and elsewhere of the probation department. There'll be no fine imposed. You're also to pay the court costs, which then grant execution order. And if you fail to pay the costs or make payment arrangements, then the clerk can collect those through various means, including levying on bank accounts, wage warrants, or other assets you may have. That doesn't collect it, then upon complete, then the court will order you additional or due police service, I should say, and give you credit for each hour you work in and out of rate set by the court, and each hour you work will reduce your judgment by that amount until paid. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file a written notice of that. The court will be entitled to the have a hearing, be represented by counsel at that hearing, and the outcome of that hearing is that you have failed to comply. At that time, the court will revoke your community control in both cases and sentence you to prison at 21 CRE to a term of 12 months, and at 124 to a term of 18 months, and order those sentences to be served consecutively. Well, actually, the city was starting at 4 or 3 or 2. 3 or 4. It's reduced one.
F3. It's an F3.
F3, okay. 36 months then. And so it'd be 36 months in that case and 12 in the other. And then that would be ordered to be served consecutively for a total of 48 months. Now, if that occurs upon completion of the prison term imposed by the court, the adult parole authority may, at their option, place you on what's called post-release control for a period of up to 3 years. And if they do that and you are found to violate those conditions, they can return you to prison, they can serve an additional period of up to 9 months for one violation up to maximum of half of the prison term for all violations, whatever violations of the felony. And an additional area of sentence the judge in this case can give you, that judge is also authorized to sentence in this case to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, thank you. Ms. Hensley, you can go ahead and sign off. Are you Mr. Osborne there at the jail?
Yes, Your Honor.
Case number 19 CR 157, State of Ohio versus Justice Noah Osborne. Mr. Osborne is appearing by Zoom from jail due to the COVID-19 situation, and then also we have in the case number 19 CR 242. Mr. Osborne's attorney is Mr. Kirk, isn't it?
Yes, Your Honor.
Mr. Kirk. He's appearing by Zoom from his office. Also appearing by Zoom is Assistant Prosecutor King, and also our the probation department also appearing by video. Now, Mr. Kirk, you and your attorney or your client both agree that this matter can be conducted by Zoom remotely rather than in-person presence.
Yes, Your Honor.
And you're in agreement with that, Mr. Osborne?
Yes, Your Honor.
All right. Now, Mr. Osborne was placed on community control in case number 19 CR 157 for aggravated possession of methamphetamine on March 4 of 2020. And in case number 19 CR 42, he was convicted of failure to appear and placed on community control, that being a fourth degree felony, and placed on community control, I believe, on the same date, March 4th, 2020. Now, there was a notification of alleged violations filed. On August 26th, court appointed Mr. Kirk after notifying the defendant in such matter for an evidentiary hearing, and that is the purpose of today's proceeding. Now, Mr. Kirk, have you had an opportunity to review the allegations with the client?
Yes, Your Honor, I have reviewed the allegations with my client and advised him of his right to a hearing. He does wish to waive right to set hearing and to admit to the violations.
Okay. All right, Mr. Osborne, the allegation alleges that you violated Rule 1 and on July 27, 2021, you were convicted of aggravated possession of drugs in Clinton County Police Court. And Rule 7, on or about on before July 27, 2021, you consumed amphetamines and THC at Clinton County Probation Department. And on or before August 11, 2021, you failed to prevent one at Clinton County Probation Department. So those are the allegations. And as your attorney indicates, you have right to have a hearing. And that's why we have this proceeding now. So where the state have to call witnesses and have them testify. We're going to be entitled to have your attorney cross-examine those witnesses and try to bring out evidence to help you on your side of the case. You are also entitled to present evidence on your behalf to all witnesses, and although we're not required to do so, we can't be required to do so. Now, in the event that it's found that you have failed to comply with these conditions, one of three things can happen. I can continue with the same conditions I previously ordered. I can continue on community control with additional conditions I think are appropriate. Or the third and most serious, I can revoke your community control, sentence you to prison for up to 12 months in the 19 CR 157 case, and up to 18 months in the 242 case, to be consecutive, so that they total 30 months possible. It could also be fined $7,500 total between the two charges. You understand all that?
Yes, Your Honor.
You understand the allegations against you?
Yes, Your Honor.
And you understand all of the rights that you have in order to have this hearing?
Yes, Your Honor.
And you understand the consequences of the possible consequences of guilty, or admission, I should say, of the violations?
Yes, Your Honor.
Has anyone threatened you in any way to get you to make these submissions?
No, Your Honor.
Has anyone promised you anything if you admit to these violations?
No, Your Honor.
All right. You have any questions you would like to ask your attorney?
No, sir.
Yeah, because if you do, I can have him, if you put in a room, a breakout room, where you can be able to talk to each other without anyone else hearing your shaking. So if you can do that, just tell me, I'll let you do that. Do you have any questions at all? Anything that we've asked here, or I've explained to you here today?
No, Your Honor.
All right. Then are you admitting to the alleged violations in the notification that was filed with the court on August 26th?
Yes, sir.
All right. Anything from the state, the probation department regarding disposition?
Thank you, Your Honor. The state, as well as the probation department, would ask that the defendant be continued on community control, ordered to complete residential treatment, and referred to drug court. Thank you.
All right. Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the recommendation by the state. My understanding is that there's a bed available perhaps even tomorrow at the counseling center. About to get him started in the treatment part of it. And then I believe he's been assessed for drug court as well.
Ms. Witt? I'm sorry, Mr. Kirk. Ms. Witt said no on this case. All right. All right, thank you, Mr. Kirk. Mr. Osborne, is there anything you would like to say?
I just would like to say that I would greatly appreciate the opportunity that has been presented by the state.
Where's that bed available, Mrs. Sturgeon?
At the counseling center, sir, we would be doing the transportation.
All right. Well, has he not been there before?
I think he has. He's actually, he's been to a couple different places. We chose that because the Adams County location and the job program for him, we thought that would give him more follow through with their transitional program available.
Okay. Yeah, I see one of the allegations back in September of last year was he left residential treatment with another chance against that order.
Your Honor, he did complete the STAR program in March of this year.
Oh, we did?
Yeah.
All right, Mr. Osborne, I know you were listening when I was on the other hearing with the woman from the program. Drug court is a program that I don't order people to go into. They have to choose to apply, and then I decide whether or not to accept. And you've been on community control, not very successfully. Community control is designed to help you stay out of prison and meet certain conditions. Doesn't necessarily focus on your sobriety. Now, you've had some treatment at the counseling center as well as the STAR program. Hasn't been very good outcome for you in terms of staying sober. And now you picked up this other charge on the county. But if you want to be in the drug court program, you have to be sincere, be honest with yourself, that this is what you want to do, and that you're ready for this, because it's a lot more intense than the regular control you've been on. Be a lot more expected of you. There'll be daily call-ins for testing, and you have to show up. You know, it's a refusal, which is a violation, subject to sanctions. You have much more programming, much more contact with the probation department and the treatment team, and you know, the hope is that you stay sober, maintain your sobriety, because if that happens, based on your record, it appears that it's unlikely that you'll commit another criminal offense. But the focus is your sobriety, but it takes commitment. And one of the things I tell people in drug court is you got to be honest. And you need to be honest with me and your treatment team, but before you do that, you have to be honest with yourself. Because if you're not going to be honest with yourself, you're not going to be honest with anyone else. So you have to make sure that you start looking at yourself and not just thinking, how am I going to get out of this one, or how am I going to stay out of prison this time, and tell them what they want to hear. If you're not really sincere about it, it's just going to delay the inevitable. And so, you know, that's where we're at right now. You know, based on what's happened so far, I wonder how committed you are. I hope you're committed, but yeah, I just wonder. You tell me.
I'm very committed, sir. I'm ready to change my life.
And where do you stand in the Clinton County case?
I was released by Judge Ruddick, and he was the one that told me to look into drug court for you, that if I was granted drug court, that he would run it concurrent.
Okay. Well, if you're sure this is what you want to do.
Yes, Your Honor.
All right. Well, court then will give you this last chance by accepting you into the drug court program. And you will be required to comply with all of the conditions originally set. Well, also, I'm going to extend your community control by a year in each case, because program is going to be a minimum of 18 months. Right now, most of our graduates have been successful in the program between 22 and 24 months on average. And so, in order to make sure that we have enough time to work through your cases, I'm going to extend your time by 1 year in each case. What I'm going to do, I'm going to fill out, I'm going to go through with drug court community control. We've already been put on community control, but you're going to be required to comply with the community control conditions of the drug court document. So I'm going to go over those with you again. Not done this before. I'm going to have to jerry-rig my entry here a little bit. So, it's the order of the court that you be accepted into the drug court, and that your conditions of community control be amended to be those of the Highland County Drug Court docket. That means you'll have to comply with your treatment plan and all the conditions that are set forth in the program description, which you have applied. Oh, by the way, I forgot to ask this, if you did find that he's an acceptable candidate.
Yes, sir, I filed a letter.
Okay. All right. Well, for some reason, I'm not finding your letters here. I'm getting finding the application, but not the letter. So I don't know what's happening. But anyway, you'll be required to obey all laws, law jurisdictions, conduct yourself in a law-like manner, report when and as directed, be truthful in all statements you make to the probation department and treatment team. Keep informed of your residence, place, and employment all time. May not change either without prior permission. May not enter or leave state of Ohio at any time without prior written permission. May not enter upon grounds of any correctional facility or communicate anything on the inmate in those facilities without prior permission. Again, you're not allowed to have any kind of weapons of any sort or any firearms, ammunition, dangerous ordnance. May not purchase, possess, use, have under control any kind of controlled substance, drug abuse, CBD, oil, cream, or any varying analog of those that might have an effect similar to controlled substance or drug abuse, as well as any not permitted to purchase or buy or have any instruments, devices, and things you use to administer them. The present administration unless you have a law restriction for both the controlled substance and those devices. Must report, provide a copy of that restriction to your probation officer, and actually you'll find that there are requirements of the letters to a doctor before they prescribe telling you in the drug court docket, so they're aware. May not contain medical marijuana product letter in drug court docket. You have to submit to testing, drug testing when it has directed. It'll be very intensive. You have to call in every day to determine if you're going to be tested that day or not. You can test it several times a week. At least initially. May not purchase, possess, use, have under control any alcoholic beverages or create present places for the soul being consumed. May not associate with any co-defendant or any person has a criminal record, member of gang or the criminal code for anybody who can inflict you with a criminal offense violating these conditions. You may not have a date of disorder, marriage, establish cohabitation, common law marriage type relationship with another without prior permission. Must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than next business day after that occurs. Provide your supervising officer with information and records so that financial information records to determine your ability to pay restitution, fees, or costs. Be referred by your supervising officer or any other probation department employee or treatment team member for further evaluation, assessment, further training. Programming. You'll roll in and follow that. Successfully completed. Pay rates, pay the court costs, pay those. You'll remain in jail until you're conveyed to the counseling center. When is that again, Ms. Turtle?
Tomorrow.
Tomorrow, okay. That'll be 9/23. And again, you have to apply to all conditions in both cases of the drug court program that you already gone over, and there is an application in the file showing that you have received that. Now, by being placed on community control rather than being sent to prison, you're deemed to consent to a search without a warrant of your person, vehicles, property, or any other place you're found or that's under your control of any nominee officer of the probation department. All right. And again, if they feel that you've not complied with these conditions, they will file a notice of that to the court. We come to have a hearing, and if you are found to have failed to comply, then at that time the court will revoke probation control and sentence you to 12 months in 157 case and 18 months in another case, and fine you a total of $7,500. And then the sentence will be over to be served consecutively for 30 months. And your post-release control, I previously explained to you, is optional and could be up to 3 years. And we overpay court costs. If you don't pay those for service, you get credit for HR work, an hourly rate set by 40 HR work, reduce your job by $100. All right, is there any further counsel?
There, Your Honor.
Hey, Your Honor.
All right, that is man in custody until wait or to the counsel center. All right. Thank you. You're made it back to custody.
Go on, you're up.
All right, Mr. C, who is this? Melanie Bowline?
Exactly.
All right. Case number 20 CR 259, State of Ohio versus Melanie Ann Bowline. Ms. Bowline is occurring by Zoom from jail. Her attorney is Daniel Witt, also occurring by Zoom. President of the state by Zoom is Mr. Prosecutor King. Ms. Witt, you and your client are both in agreement that this matter be conducted by Zoom remotely rather than an in-person hearing.
We are, Your Honor.
And you agree with that, Ms. Bowline?
Yes, sir.
Okay. Now, Ms. Bowline, since we're not having this hearing in person in courtroom with you being next to your attorney, at any time if you would like to speak, or just tell me, and I'll put you in the hearing. We'll break out when the two of you talk privately without anyone else now hearing or seeing. Okay?
Okay.
All right. Ms. Bowline has entered a plea of guilty to grand theft of a firearm, a third-degree felony. The court ordered a pre-sentencing report, and the case was also referred to the drug court docket. I have received the PSI and reviewed that, and also see that she has been screened from drug court, and Ms. Sturgill has found that she's meets the criteria. Anything from the state regarding sentencing?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. This would be her third felony conviction. She has 2 prior felony convictions for possession of drugs. She's had multiple opportunities of treatment in the past. She previously received treatment in lieu in Warren County. That was eventually revoked, and she was ultimately sentenced to prison. According to the PSI, she's had opportunities at Lingoff. She was admitted there on July 2nd of 19, walked away 4 days later. She has been to the counseling center. She was admitted there on March 4th of 20, and 2 weeks later she left. It also looks like she's been on EMHA before out of municipal court. She cut the bracelet off after 3 days of discomfort. So, based upon the defendant's criminal history, her track record while under supervision, the fact that she's had numerous opportunities of treatment, the state would ask that she be sentenced to term incarceration. Thank you.
All right, Ms. Witt?
Yes, Your Honor. We are asking the court for community control and drug court. It seems to me that Melanie is the type of person that drug court was designed for. She has a 25-year history of drugs, and that's evident, as Mr. King noted, that she does have a lengthy criminal history starting back in 2004, but every single one of the charges that I see has something to do with drugs or alcohol, or drug or alcohol related. What would be different now? I've asked Melanie that same question about treatment. She is very positive about drug court and wanting that extra layer of accountability and support system, but I'll let her speak to that for herself. But we asked the court for community control and drug court and a chance at that.
All right, Ms. Bowline, anything you'd like to say?
Yes, Your Honor. I do apologize to the victim and the court as well. I have had a long history of drugs. I hate jail, don't get me wrong, but, you know, it has set me down. It has cleared my mind, and each day I get clear-headed. I am very positive, and whatever happens, I'm going to make the most out of it, but I would like this chance, because, you know, I can't change my past, but I do want a chance to change my future. I have had a lot of time to reflect, and I'm 109 days clean today. I'm a completely different person sober. I realize that my addiction hasn't only affected just me, and I've been very selfish in that, and I know that. I know what kind of person I do want to be, and that's the kind of person who fights for my sobriety and recovery every single day, which I didn't give a crap before, I ain't gonna lie. But I haven't had this much time sober in a long time, honestly, and I'm tired of this. I'm sorry. And if I could get a chance at this, I mean, I need somebody to help hold me accountable and to be responsible and to help me relearn to be a fully functioning member of society, because somehow I've lost myself along the way. So I'm just begging you for a chance to do this, sir.
Was the firearm recovered?
Firearm was never recovered, but the victim is not seeking restitution.
I don't see a victim impact statement. Did he have anything to say about sentencing?
Yeah, oh, sorry.
Not that I'm aware of, Your Honor.
So did you just pick Mr. Rose's apartment out randomly, or did you know he might have something in his apartment that might be worth stealing?
I didn't know. I just kind of came there, was there visiting, and I was out of money and I needed drugs, and that just kind of fell into my lap, honestly.
Was he the first place you went, or did you try other apartments first?
I was just there. He was a friend of mine.
So you knew him?
Yeah, I knew him. It wasn't just random. He actually has told me that he just wants me to get treated. He just wants me to get help. So I've spoken with him since I've been here because I've apologized to him on the phone. I did call in to apologize. He's living in Texas now. He just wants me to get help. He's really ill right now. He's got cancer. So I want to make sure I apologize to him before if anything happens.
He's moved to Texas, you say?
Yes, sir.
How did you know Mr. Rose?
I met him because he was my mother's neighbor, and then I used to go over and help him because he just needed help doing things at his house, and we just became friends.
All right. Anything else from anyone?
No, Your Honor.
All right, well, Ms. Bowline, you have had a history. You have one prior conviction for drugs. This bothers me in the sense it's a crime against an individual. There was a firearm stolen, but based upon circumstances, it appears that Mr. Rhodes is being fairly understanding of the situation. And based on your past history, of course, stating that you would benefit from drug court, as I said to the other persons this afternoon, is I don't send people into drug court, they have to apply. You have applied. I do have a letter from the surgeon stating that you are the qualified and acceptable candidate. And I have your application in the file. And you need to understand that this is a much more intensive program than just regular community control or your intervention lose you had back at Warren County that was revoked. And you have to be honest about this with yourself. Because if you're not going to be honest with yourself, then you're not going to be honest with anyone else. But this is going to be a lot more difficult, a lot more intense, and it will be effective to apply. There'll be a lot more resources afforded to you, but if you're not serious about this, then you're wasting your time and anyone else's time. So is this something you're certain you want to do?
So honestly, because I have been to prisons, I know it's so much easier to go there and sit, but I'm wanting to do this work. I need somebody to help me accountable. I need it and I want it.
All right, well, then the court will accept your application and fix you in the drug court, and it's ordered that you be put on 3 years of community control supervision under the probation department, under the terms and conditions of the drug court docket that you have previously seen and acknowledged in your application as filed with the ILS court. So it's ordered the court that you be required to apply for the next 3 years with the following conditions. Pay all laws, all jurisdictions, conduct yourself in all manner at all times. The court will then ask directions and proof all statements you make to officers regarding your condition. You must keep and inform your residence, place, employment all times, and not change either without prior permission. You may not leave the state of Ohio any time without prior permission. You may not enter on the ground of that correctional facility or may communicate with or attempt to communicate anyone within the facility without prior permission. You may not purchase, possess, own, use, or have under control any firearm, ammunition, dangerous ordnance, since it's already a violation of both federal and state laws to do that. There's also conditions of your community control and not have any other weapons any other time. You may not purchase, possess, use, or have under control any kind of controlled substance and drug abuse, CBD oil, kratom, or any or analog of a controlled substance drug abuse that may have effects that are similar to those. And you're not permitted to have any device, instrument, or thing that can be used to administer drugs or prepare the administration unless you have a lawful prescription copy which must provide to your supervised officer in 24 hours receipt. You're not permitted to obtain a medical marijuana card while you're in the drug court docket. You must submit to drug testing when and as requested by the probation department or the treatment team. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage or be present in places with sold, being consumed, even otherwise unlawful. You may not associate with anyone who's a co-defendant in this case or any other person has a criminal record, member of a criminal gang, or any other criminal group, or any person has in the past or could in the future unless you commit a criminal offense and violate these conditions. That applies to any family members who fall within that definition unless you live with them immediately before the commission of this offense. After the date of this order, you may not marry or establish cohabitation or common law marriage type relationship with another person without written permission. Must report any contact to law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that happens. You must provide your supervising officer financial information records so your ability to pay any fines, fees, or costs of your review. If you're referred for evaluation or assessment by the probation department for any further treatment or programming, you have to submit to that. If there's a recommendation for any type of programming, you're to enroll in and successfully complete that. You pay the court costs and make a payment arrangement to do that. Remain in the jail until conveyed treatment. What date is that, Mrs. Sturgill?
The 28th, sir, and they will pick her up.
When is it again?
The 28th.
28th, and it is Lindau?
Georgia Harris House.
Oh, okay, sorry. Now, you'll be required to apply again, with, as I said, with all conditions of drug court docket, and it's all conditions of your treatment plan recommended. Now, sometimes in treatment plans, the treatment aftercare, they may give you some options, but they make recommendations. Whatever they recommend is what you do, not what you want to do, but what they tell you to do. Now, by being placed on community control rather than being sentenced to prison, you're deemed consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property places under your control, or where you're found at any time, any officer of the probation department. Won't be any fine imposed. If you require to pay the court costs as a sub-order, and if you don't make payment arrangements to pay your costs, the clerk can collect that by various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't accomplish it, then the court can order you to review service and give you credit in this county, by the way. Give you credit for each hour you work, in and out of set in the court, each hour you work, reduce your judgment by that amount to pay full. Now, in the event that the probation department feels that you're not compliant, they'll file a written notice of that in court, provide you a copy, and you'll be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court will revoke your community control, terminate you from drug court knocking, and sentence you to prison for 36 months and fine you $10,000. If that happens upon completion of the sentence imposed by the court, it is possible that the adult parole authority will place you under what's called post-release control supervision for a period of up to 3 years. It's optional. It's their decision, not the court. If they do, you supervise on the conditions they set, and if during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to 9 months for one violation, with a cap or limit of half of your prison term for all violations. But if you violate, or if you commit a felony, then in addition to whatever sentence to be imposed by the judge in the new case, that judge is also authorized to sentence you to a term of 1 year, whatever time is left on the post-release control, whichever is greater. And if that happens, that sentence would have to be served consecutively to the new sentence. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Questions, Ms. Boland?
Yes, sir.
All right, thank you.
Thank you.
All right, Mr. Swisher, is he next?
He's supposed to be brought back by Talbert House. Haven't seen anybody.
Okay.
And
All right. What's your name?
Brett Swisher.
Oh, okay.
well, I guess he's not being
Your
brought.
attorney's Mr. Armstrong, with it.
Denny Kirk.
Oh, okay. Mr. Kirk's not on. Was here a minute ago. Huh. All right. Who else do you have this with?
Raricha.
Rico, you're muted there, Mr. Smith. All right, officer, if you could have Mr. Swisher step out, and we'll do Mr. Rarica.
He's supposed to be iClouding in or zooming in. Is he in the waiting? Rarica's supposed to be zooming in from an outside address.
Oh, he's not in prison?
No, we're done.
I don't believe there's anyone left that's in custody except.
Okay, all right, never mind.
We're done with jail, yes.
Okay, so we don't have anyone else in jail except Mr. Swisher? Yeah.
Swish.
Right, get up with Denny, we need him on the Zoom for Derek Rarica. Bring
Swisher.
Have Mr. Swisher come on back in, Deputy, I'm sorry.
Okay.
All right. Actually, I mean, what time is he sent for? I think so.
He's at 1 o'clock.
1 o'clock.
I wonder if Danny thinks that's one that we're going to do in person.
He hasn't shown up, but
Okay. All right, and then the others are set at 2, Mr. Rarica, Clifford, Miller, so they haven't actually tried to sign in yet, I don't believe.
well, Rarica is supposed to sign in, but the rest of them say no emails, so they,
Okay,
I assume
the
they're.
others are thinking they're being person.
That's what I would
All right,
assume.
so it looks like the others that we have other than Mr. Rarica, Mr. Payne, is going to be in person.
We do have Lambert.
Except for Van Ness and Engel.
Van Ness,
There are 3.
Oh, they're at 3 o'clock, okay.
Yeah.
Yeah, Van Ness and,
Angle.
Engel.
Lambert and Adams are,
Engel is, supposed to be by Zoom, and, Van Ness,
Both.
that's it, okay.
both are. Lambert and Adams were two of, well, Mr. Wagner was waiting to hear from Adams.
Oh, okay, we've added Lambert and Adams today for final pre-trials this afternoon. Are they in custody?
I don't believe so.
Okay. Yeah, I know this name is not, I just Kirk's here.
There he is.
We have Mr. Swisher actually on Zoom.
Okay.
The jail brought him, back to the, there, so bring him up here, which is fine, that's what we intended, and I guess we can cover that. You have your phone or something, you can go,
Yeah, I should be able to try to get on my phone and follow up up down to the office.
or you can go and, use have Ben, from Mrs. Poyer, see if they can sign you up on, the computer out of the desk.
Okay, I'll see if we can get in there. I'll get the code, so I'll have the code on the in front.
All right. All right, so, Ms. Witt, Mr. Miller, we don't have an email for him, so you don't know if he's aware of a Zoom possible hearing or not?
I'm not sure, but I can try calling him now.
Okay, if you can call him, he said at 2:15. Mr. Rodriguez is supposed to be calling in at 2 o'clock, so we do have his email. So, see what we can do there.
Well, Your Honor, you just frustrated again.
What?
You said you just frustrated
Yeah,
again.
I'm sorry.
But it was incredibly hot.
Let me,
But once I figured out that you didn't actually have to wear a mask, only if you were in the bathroom,
Case number 21 CR 87, Dave Ohio versus Brett R. Swisher. Mr. Swisher is appearing by Zoom from the jail. His attorney is Dennis Kirk. He's appearing by Zoom.
Recording in progress.
And appearing on behalf of the state is Assistant Prosecutor King. The defendant is charged in a 6-count indictment. He was charged with 6-count indictment, and he entered a plea of guilty to 2 counts of aggravated trafficking and methamphetamine, third-degree felonies. The court referred the matter for a pre-sentence investigation, and I have received that each of the attorneys have an opportunity to review a summary.
Say that, Your Honor.
Of Your Honor.
Okay. All right, Mr. Kirk, you and your client both agreed to conduct this matter sentencing by Zoom remotely rather than in person.
Yes, Your Honor.
All right. And that's okay with you, Mr. Swisher?
Yes, sir.
Now, if you have any thing you need to talk to your attorney about, since you're not present in court, just tell me and I'll put you into a breakout room, which means just 2 of you on the screen talking. No one else will be able to see you or hear you. Okay?
Yes, sir.
All right. All right. So, the matter was referred, as I said, for a pre-sentence report, and I reviewed that. And this time I'll ask the state for comments regarding sentencing.
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. This defendant has 5 prior felony convictions. And looking at the PSI earlier, he has been on community control in the past in Clinton County, violated, and was ultimately sentenced to prison. I also saw that he was admitted to STAR in February of 19, was unsuccessfully discharged a month later. So given the defendant's criminal history, that he's had opportunities in the past, and that these are drug trafficking offenses here that we're dealing with, it's the state's position that he's not amenable to community control, and that a term of incarceration is appropriate. Thank you.
All right, Mr. Kirk.
Thank you, Your Honor. Would ask the court to grant community control in this case. I know typically with trafficking, prison would be the normal route. However, there's kind of a unique set of facts here in that the defendant is currently in the Talbert House CBCF in Warren County. I believe the court received copies of reports and letters from the Talbert House. The reports I read were pretty positive. It appears that even the director of the program has nothing but good things to say, and it appears in review of those reports that everyone is behind Mr. Swisher. They believe he is benefiting from the program he's in right now, and believe that continuation in that program and segueing over into our court with anything after that would be a very good path to take. So in this case, we'd certainly ask the court to consider that. Also, I believe the date of the offense is a little bit older in this case. It's not a recent offense that he's addressing here in Highland County. It was back in November of 2020. It's almost a year ago. And so it appears that in this case, Mr. Swisher is addressing his concerns and in doing so in a very positive manner. And I believe in this case, prison might derail those efforts for sobriety. So I would ask the court to grant community control and any aftercare and additional programming after release from the Talbert House. I believe it's expected he's to be released sometime mid-October. Thank you, Your Honor.
All right, before, again, Mr. Eureka, is that you there?
Yes, sir.
All right. You're heard by video, but it's for the law proceeding, so you need to go back and put on a shirt, not sleeves. You don't take handcuffs for it.
Got it.
All right, Mr. Swisher, anything you would like to say?
Yes, Your Honor. This was a good opportunity to go to CCC, that you gave me that opportunity at my arraignment to go ahead and work on my problems in the past. And I finally got to go and worry about me this time because my wife was incarcerated. My kids were grown, So I took the opportunity to fix my problems. And I got a job working 90 hours a week. I do church 3 times a week. And I'm really sincere about fixing me. That way I can provide better for my family and myself. I think I don't want to apologize to the court for my actions. Thank you for listening.
So you, if you are released, you're going to be living back in Leesburg?
Yes, Your Honor. I have an ankle monitor for 45 days through Warren County, and they agreed to whatever your stipulations were. They would work together.
And what's your proposed employment?
October 11th is the out date, and then I have to be at FRS on or before the 12th.
Okay.
In the world for aftercare.
And then what about, did you mention something about employment? You have any?
Not yet, but my father offered me a job as long as I complete successfully, and I can work with him doing conveyor belts, but I have to complete the 45-day ankle monitor and your probation.
All right, that's Mr. You talking about Mr. Tate?
Yes.
Okay, you're. All right. Well, typically with these offenses, I'd be inclined to sentence you to prison, Mr. Swisher. But since you've been in the CBCF and have done extremely well, and you're nearly completed that program, I'm going to give you one opportunity, one only, to show that you are serious about your change. So it's the order of the court that you be placed upon community control for a period of 3 years under the supervision of the Highland County Probation Department. Now the conditions are that you'll be required to obey all laws, all jurisdictions, conduct yourself in a law-abiding manner at all times. Again, up to 3 years supervision. You'll be required to conduct yourself in a law-abiding manner at all times. You must report when and as directed to the probation department. You must be truthful in all statements you make to them, as well as any answers to questions that they ask you about your supervision conditions. You must keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You must have that with you when you are traveling. You may not enter upon the grounds of any correctional facility once you're discharged from your community CBCF, nor may you communicate with or attempt to communicate with anyone who is an inmate in any of those facilities without prior written permission of your probation officer. You are not permitted, because of your convictions, to purchase, possess, own, use, or have under your control any firearms, ammunition, or dangerous ordnance. If you do any of those things, that would be a felony violation of both federal and state law. There's also a condition you not have any of those while you're under community control, nor any other weapons of any other type. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug abuse, or kratom, CBD oil, or any other type of variant of controlled substance that has effects similar to those of drugs abuse, or any other instrument, device, or thing may be used to administer them or prepare them for administration unless you have a valid legal prescription. And if you do, you must provide a copy of that to your probation officer within 24 hours of receipt. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in place of the soul being consumed if it's otherwise lawful. They're not to associate with anyone as a co-defendant in this case or any other person that has a criminal record, member of a gang or a criminal group, or any other person that has a past that in the future influence you commit a violation of the law or these conditions. Unless approved by a supervised officer, that also applies to any family members if there are any involved in that definition. You may not, after the date of this order, marry or establish cohabitation of common-law marriage type relationship with another without your permission. Must report any contact with law enforcement or arrest, citation, conviction, or the charge of violating the law not later than next business day after that occurs. You must provide your supervising officer financial information records so you're willing to pay any fees and costs of your review. If you're referred by probation for any further evaluation or assessment for further treatment beyond that ordered by the court, you're to submit to that. If there's any recommendation program, you must enroll in and successfully complete that. You'll be required to pay the court costs and make payment arrangements to do that. You'll be required to comply with any treatment recommended by FRS. And you report to the probation department not later than the next business day after you are released from the CBCI. Now, by being placed under community control, you're deemed to have consented to a search without a warrant of your residence, your person, vehicles owned by you, used by you, or any property placed under your control where you're found at any time by any officer of the probation department. Be no fine, be no driver's suspension. If you don't pay your court costs, make payments on the court, can't collect that through other means, clerk by letter or bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you could go over to your service, be given credit for each hour you work, and another way set up by the court, each hour you work, reduce your judgment by that amount to take control. Now, in the event that the probation department feels that you have failed to comply with these conditions, they will file a written allegation of that with the court. You'll be entitled to have a hearing. If the outcome of that hearing is that you have failed to comply, then the court at that time can revoke your community control and then send you to prison. And if that happens, once you complete the prison term imposed by the court, and prison term could be up to 72 months, but it's 36 months in each count. And once you complete the prison term, then the parole authority could decide to put you under police control for a period of up to 3 years. If they did that, you'd be supervised at the term they set, and during that period of time, they failed to comply, or they felt that you failed to comply, then they would have found that you failed to comply, then they could return you to prison for up to 9 months for one violation of the maximum of half of the prison term for all violations. But if you committed a felony, then an additional whatever sentence the judge in litigation imposed upon you, the judge could also sentence you to additional period of, in this case, of 1 year, whatever time left upon that 3 years post control for committing that offense while under BRC. Now, also, there is a mandatory $5,000 fine in each count. And the court is going to go ahead and impose that since you're getting community control. And it's going to give you the incentive as well to get this taken care of. So, you're going to pay $5,000 on each count. Total $10,000. That's to be paid in 3 years, and that would be September 22, 2020. If you don't pay that, the court could extend this up to 5 years for that. All right, is there anything further, counsel?
Yes, Your Honor. There's also restitution that was addressed in the plea agreement.
Okay.
$625 joint several with Brandy Swisher.
To who?
Joint and several with Brandy Swisher to the Highland County Task Force.
Okay.
And then $250 alone to the Highland County Task Force.
All right, court orders that to be paid. That will be paid through the Highland County Victim Witness Office. And you pay these search fees that are required. All right. I believe that completes the hearing then. And we'll give Mr. Rodrigo next then. Thank you.
Can I ask a question, Your Honor?
Yes.
My wife is incarcerated in and we've been married 25 years. I've got permission from Warren County for letters. I just was protecting myself because we've been writing each other. And who do I gotta talk to get permission?
Talk to the probation officer, that's their call. I think it might not be a good idea, because one of the things you made to me, the comments you made was you need to take care of yourself rather than worry about her, which is exactly right. That's what I tell people all the time, is that, you gotta take care of yourself, not worry about other people. And, she will be one of your triggers. In my view, it's probably not a good idea, but I'll refer to the probation department. And so, if they say no, then no, for me. I don't care what Warren County says.
Thank you, Your Honor.
What you're gonna find is, probation Hyde County is gonna be a lot tougher than Warren County. Because they've got a real hard-ass judge. Okay, thank you.
Your Honor, while I'm still on the Zoom, I also had Bobby Clifford, but it was scheduled to be in person. Did you want me to remain on Zoom for that one or come into the courtroom?
Why don't you come to the courtroom? I know we got 3 people here, and I'm not sure who, but, yeah, because Mr. King's gonna have to come over anyway, so, yeah.
Okay, thank you, Your Honor.
Thank you. All right. Case number 21 CR 111, State of Ohio versus Derek Rica. You're Derek Rica there, appearing on the screen. It has Derek down in the corner.
Yes, sir.
All right. This hearing is being conducted by Zoom due to COVID-19 issues, and Mr. Rica is appearing by Zoom. His attorney is Daniel Witt, appearing from her office, and from the prosecutor's office, Mr. King. Defendant charged with aggravated possession of methamphetamine and fifth-degree felony. I believe this is a pretrial. I see that there was a motion filed for intervention on the 3rd of September, and I signed that, and it was also stipulated question. So I'm not sure that there's an entry in there. Yeah, there is an entry that refers into the. So this matter is set for a plea action on the 21st of October. Have you been evaluated yet, Mr. Rica?
Yes, sir.
Your Honor, it came up at the last pretrial that he has a prior felony offense of violence out of California, so he's no longer eligible for ILC.
Oh, okay. All right. So what's the status then of the case this way?
I have discussed that with Derek, and if we could just set it out for a plea for next week, that should be fine, and give him an opportunity to come in my office so that we can go over everything.
Okay, all right. Well then, I know we're set for I think there's another pre-trial perhaps set, no, actually set for a trial on the 12th. So, yeah, see if you get him in as quickly as possible so we get this in before next Friday, so we'll have set out for doses.
Okay, will do, Your Honor.
All right, thank you. All right, I think that's it then on Zoom, Mr. King. If you can log off, come on over. Appreciate it.
Yes, sir. I'll be over.
Am I?
Do you have Miss Lambert, Miss Adams here? Do you have Miss Lambert, Miss Adams here? Are they here, Lambert and Adams?
Adams is JD's.
Oh, I'm sorry.
Okay, that's what you just just look for me like.
Well,
You only have Miss Lambert,
Oh,
correct?
this is one for you.
okay. I thought it was written on the sheet that was, right. Is Miss Adams here?
That's when JD was supposed to call after we broke this morning and try and find out if she could come into his office or
All right.
if
Let's
she's
see, I'm looking here.
laying low.
Okay. 2:30 is Cliff and Wallace, and that's our route. Wait a minute.
Wait. Clifford and Miller, and neither one of them have shown up here. No emails.
Right. Clifford is set
for 2 o'clock.
2 o'clock.
And that's one, Mr. Kirk.
Who's his attorney?
Mr. Kirk.
All right.
Clifford.
All right. As soon as Adam gets here, we'll do that. And then, you have anyone else, Mr. Burdick?
Should be the last one.
All right. Okay, see, Abel and Van Ness, are set, I think.
3 and 3:30.
3 and 3:30.
Yes.
And Miller is,
2:15, Ms. Witt.
okay. And he's not here.
And Mr. Sharonberg is Miss Barber. Okay, that's probably him. He was here at 8:30. He was here.
She's here, and I assume he is. See, probably my, I think I got my, docket stuff from all the while, so, who's at 3 o'clock?
Clifford.
Right.
This is with Mr. Kirk right now.
And then is who, Armstrong?
Then we go to, Mr. Armitage doesn't have anything.
Okay, till 2:30, all right.
He doesn't have anything today.
Yeah, 2:30, got Cliff and, well,
That's yesterday's.
Okay, no wonder I'm confused.
Okay. Mr. Clifford at 2, and then we're at 2:15 with Mr. Miller.
Oh,
With,
that's Clifford's file here.
okay.
For some reason.
All right.
All right.
On the record for Clifford.
Oh, there they are. Okay. All right, State of Ohio versus Bobby Clifford. 21 CR 127. Present for the state is Assistant Prosecutor King. Present for the defendant is Attorney Dennis Kirk. Have Mr. Clifford. It's now 2:18. This matter was set for a pretrial at 2 p.m.
Want to get
And Mr. Kirk, have you had any contact with him?
I have not. I have sent him a notification to contact my office, but then I've heard from him.
Well, I have a notification from the probation department yesterday by fax that he's failed to report having any contact with them since September 9th. So, we're going to take this issue and see what happens. If you should hear from him before the end of the day, there's I think might be a plausible excuse, let me know. We'll consider it.
Thank you, Ryan.
All right, and who else do you have?
That's all that I have.
Okay. All right.
Was Miss Witt coming over, or was she staying in her office?
She's looking over.
Okay.
Well, I assume she do that, but I didn't specifically tell her, so maybe better follow and tell her.
Okay. Charles Miller for her, then Mr. Sharonberg with Miss Barger, and Patner has Miss Lambert.
Okay, are you ready for Miss Lambert then?
I am.
All right, yes, please.
Miss Lambert, come up here, please. Make sure you have a phone, it's off. Just have a seat here, please.
Case number 21 CR 94, State of Ohio versus Melissa Lambert. The state is Assistant Prosecutor King, Defendant's Attorney Capner, and you're Melissa Faye Lambert.
Yes.
Lambert is charged with burglary, a second-degree felony, and I believe this is the final retrial. And let me see what our trial date is.
I believe it's October 14th.
Right. Set that, sounds logical. do we stand on this case, counsel?
I think at this point, we're just ready to proceed to trial, Your Honor.
Okay. Discovery complete on both sides,
It is.
and there are no other pretrial motions, correct?
That's correct.
Okay. And has there been a written rejection of the plea offer?
Well, we need to get out and prepare that.
All right. Slander, what the prosecutor is doing is there's a practice we follow in this court that if a person wants to reject a plea offer, they sign that stating that they're aware of what it is, and then the prosecutor keeps a copy and your attorney keeps a copy. I don't see it. I don't know what the offer was. I don't care. It doesn't matter to me. But it's just simply so there's a record that the person that was charged was aware of what it was and chose not to accept. We do this in all cases. There was a case a number of years ago that the person was allowed to have their conviction set aside because they claimed their attorney didn't have a plea offer. Unfortunately, about 30 years ago, I had that happen when I was prosecutor. And so it's just simply so for the record for that. And then if it comes up later, the attorneys can just say, here's the proof that they were aware. So he's going to have that for you. And all you're doing is saying you're rejecting that offer. And again, I don't know what it is. I don't want to know.
Well, Mr. Chairman, is it possible to give Ms. Lambert the form that we normally give them to show time of what they're supposed to be here? Could we set that trial date?
Okay, yes, give her a sign notice.
Yes, could we set that after our trial?
Yeah, October 14th at 8 a.m. I have it on my notes here. I don't see the assignment notice, so, but yes, that's the date it would be. Actually, I better check with, this, lawyer to see if that's, done.
I think I don't think I have the assignment notice. I do in my calendar.
You may have, that one may have slipped through the cracks with, what she had going on. Yeah, 10:14 at 8 a.m.
Yes, sir.
This is just a one-day trial.
Yes, sir.
Okay.
Yes, sir. I want to have Ben call JD to see if he's got a hold of Adams to see.
She was supposed to be here anyway.
Correct.
I think he told me that he was going to talk to her. He had got her to be able to sign the paperwork.
Yeah, he can't get her to come in.
JD was not, just got in touch with me. Because we were going to continue it if she called him so he could get her into the office to sign some paperwork. All right. Anything further, counsel?
No.
All right, thank you. All right, Ms. Witt, let's see. You have. All right. Case number 21 CR 20, State of Ohio versus Charles E. Miller Jr. Present on behalf of the state, Assistant Prosecutor Kane. We have the defendant, Assistant Attorney Daniel Witt. The defendant is not present. This is a hearing that is scheduled for pre-trial at 2 o'clock, now 2:25 p.m. Ms. Witt, have you had any communication with Mr. Miller?
I spoke with him on September 15th, and he was supposed to come into my office to go over discovery on September 16th. However, he did not come in, and I'm not able to reach him now. His voicemail is not set up.
Well, I also have your motion to withdraw as counsel due to a conflict, which I'm prepared to grant. But I do have notice from the probation department that he has failed to report or have any contact with them since August 17th. So, court will order a needless to issue, and will appoint counsel to, so I'll go ahead and do that now so that you can get the file where it is at this point. So when he is located, they'll be prepared to file. All right, thank you.
Okay, thank you.
Let's see, well, is that the last one you have?
I have Manring, but he's by Zoom.
Oh, is he later?
Yeah, it was 2:45.
Ms. Barger is with Sharonberg now. So.
Well, you got 15 minutes, you back there?
All right.
Yeah. Get a drink and get ready.
She's ready.
Yeah, I'll see you in here. Henry, doesn't have anything with Vanessa. I guess we're doing all those on the 3 o'clock notice, or the 1 o'clock notice.
I think there's a separate invite for Van Ness, same thing.
Yeah, but I think it's all under the same, one, we only have one here, 45.
She's reviewing plea. She needs her other 5 minutes to
Case number 21 CR 130, State of Ohio, Mr. John William Sheriff. Present for the state, Assistant Prosecutor King, Defendant, Attorney Sarah Barber. You are John William Sheriff.
Correct.
And Mr. Sheriff is charged with one count of possession of cocaine pre-trial. The court has received a stipulated question for intervention for. And have you filed a motion yet?
Yes, Your Honor. It was filed this morning.
Okay, I haven't seen it yet. All right. All right, the court will order that the matter be referred to the probation department for a report, and we'll set a matter for hearing. Let's see, what's our next hearing date set?
Your Honor.
Yeah.
My client does have, he's having total knee replacement on both knees. He's having his first surgery on October 4th of this year, and then again on November 14th. It's the second procedure.
Okay. Well, we have a final pre-trial set on October 20th. So, the first one's on the 4th of October. Your first replacement's on October 4th?
Yes.
All right. They told you how long you'll be before you be able to get out and about?
About 5 weeks on each one. But I foresee myself being able to make it here.
Well, if nothing else, we can do it by Zoom. Do you have a computer or a smartphone that you can use for the internet? You don't? Okay. You know anybody that has one? All right. Okay. Well, tell you what, we'll just go ahead and leave it on for the pre-trial. On a pre-trial, we'll go ahead and set that date. And then you stay in touch with your attorney.
Okay.
And if you're not doing well, I'll understand, and it'll be continued. So right now, we'll just figure at October the 20th at 2:30 for the hearing. Now, are you in any kind of treatment program yet?
Yes,
You handle that for your attorney? Okay.
yes, I completed this, and I completed my DIP out here, and I got 2 certificates on that, and I'm
So you're still in,
yes.
All right. Well, you'll need to go down to the probation department as soon as you get done here today, and tell them that you need to be assessed, and they'll have to do a report.
Okay.
And, so again, if there's any problems with your recovery that's major surgery, no matter how young or old you are, so, if there's any problems, just let your attorney know.
Gotcha.
And we can continue. All right.
Thank you very much.
So, you're already noticed for the 20th at 2:30, so just plan on being here then. But go ahead and go down right away to the probation department then.
Okay, I found her this morning, but no.
Yeah, so you can take it back and tell them you need to make an appointment for an intervention report.
Okay.
An assessment.
All right.
They'll have this, they'll look at your paperwork, whatever, and who are you seeing now for us?
I'm seeing Francis Cochran and Eric Armadillo.
Where are they at?
He's been going to another chance.
Oh, another chance, okay, that's what he agreed
yeah,
to.
that one.
Are they Greenfield or Hillville?
Greenfield?
Yeah, okay, that's what I thought, because they talked about opening an office here, I don't think they have yet.
Yeah.
All right, thanks, Mr. Shepherd.
Thank
See
you.
you back then, good luck with your surgery.
Okay, thank you.
So are you still using barber?
Yes.
Okay, I didn't know if I was supposed to change or not.
Nope. Not doing that
Just
yet.
a matter of curiosity, who did you marry?
His name is Scott Ford. He's not actually from Hillsborough.
Scott Ford.
Mm-hmm.
Huh, okay, where's he from?
Amberley Village.
Amberley Village, Cincinnati?
Yep.
What's he do?
He now works for Queen City Mechanicals. He's a construction worker. He's good, skilled with his hands. He does not like to be inside. If he sat at a desk all day, I think he'd go crazy.
That's kind of Native American, somebody's handy.
Opposites.
He is quite handy to have around. I will say Dad enjoys himself too, so.
Are you living here or somewhere else closer?
We live here. Yeah, we bought a house, 247.
Yeah, this is the first pretrial, all right. Okay, yes.
On the record.
Case number 21 CR 126, State Labor's Commissar Manning. You are Commissar Manning, is that correct?
Yes, sir.
All right, we had intended for this to be a Zoom hearing, Mr. Manning, but apparently you didn't get notified. Your attorney, Ms. Witt, and Mr. King, the assistant prosecutor, are both on my street here. So we'll go ahead and do this, because this is, I've got another one scheduled here pretty quickly. Mr. Manning is charged with property handling firearms and motor vehicles, fourth degree felony. This is the first pre-trial. Final pre-trial is on the 20th of October. Trial date is November the 8th. I see that there's been a request, okay, bill of particulars was provided, and a lunch was discovered by the state on Monday. And, well, this is good for camera, like, great there. All right, and you get those, Miss Witt?
Yes, sir.
All right, well, yours will be due by the final pre-trial. And do you anticipate any pre-trial motions?
No, Your Honor.
All right. Has there been a written plea offer provided yet?
There has.
Is your client aware of that?
Not yet, but if you will come over here after he leaves there.
All right. Well, anything else that has come before the court on this?
No, Your Honor.
All right. This would likely come right over to the office. You know where it is, right over here by the old fire department. Okay. You're looking right out that window. That's the old fire department building, right there in the corner. Just go down to the first door on the left, second door on the left. And it'll be the Hacker Law office. That's where Miss Witt is. What's that address?
127.
127 North.
Also, simplest, I guess it's
Pardon me?
same street as the probation department?
No, that's East Main. It's this way.
Okay.
Yeah. Probation is east and the sheriff's office is north. Right by the old fire department there. Yeah. Okay. So going over there right now. And we'll see you back here. Thank you.
Where do I change my address that you guys are going to be the right source?
Pardon me?
Where do I put in a change of address at for you?
Probation department.
Probation department?
Yeah. So go down there after you see Miss Wood.
Sounds good.
There's like 3 fire doors on this side of the street.
All right, he's on his way over.
Okay, thank you.
And he said he's got a change of address too.
Okay, good. Okay, thanks.
All right, let's see, we got 2 more people. And, man, Ness is there.
Recording in progress.
Okay, we lost, oh no, there he is, all right. Mr. Van Ness, if you would unmute yourself, please. There's a little button, if you're on a computer, it'll be down in the right, or your lower left-hand corner. If not, on your phone, you gotta scroll all the way down. Should be a little microphone with a slash through it. Or if you're on a phone, if you go scroll down to the bottom, you should see something that says, either has a symbol or says start audio or activate audio, something of that nature.
Unmute. There.
There you go, all right. Case, this case number 21 CR 112, State of Ohio versus Sean Van Ness. And you're Sean Van Ness, appearing there, the plaid shirt.
Yes, Your Honor.
All right. Mr. Ness, attorney Alex Deardorff is present, as well as Mr. King. This hearing is being, on behalf of the state, hearing being conducted by Zoom rather than in person. Now, I see we actually have a motion to suppress next week, 29th at 2 o'clock. So that's still on.
Your Honor, I filed a motion to continue that hearing. That was actually filed on September 16th, and I did speak to Ms. Deardorff. She has no objection to the continuance. The criminalist from the crime lab is not available on that date.
All right. Let me look. What's the issue in the suppression motion? Is that officer for that person?
It's a lengthy motion. There's about 47 prongs.
Looks to me like it's a can motion. Let me tell Ms. Deardorff, tell me what the point is of your motion.
Your Honor, I knew this was a blood draw at the beginning, so I filed a motion covering all the issues that I've run into with any blood draws, just to preserve the record before the 35-day time limit expired. I'll be able to narrow that if it does proceed to a motion to suppress with a supplemental filing, clarifying for the court. But the biggest reason I don't have an objection is because I'm still waiting on the discovery. I did receive the discovery, but there was some things that needed to be placed on a USB drive, which I've mailed to the prosecutor's office. So the motion I may be able to withdraw that after finishing my review of the discovery.
All right. All right. Then, once that's done, will that complete discovery from the state?
Yes, Your Honor.
All right. Have you provided your discovery yet, Ms. Deardorff?
I have not, Your Honor.
And the local rule requires it to be done by final pretrial, that's today. So you might want to look at the local rules to make sure you follow the procedure. So you can provide your discovery, initial discovery, by next Friday, and then for supplement it as the case goes, as well as state, that would be on the. All right.
Yeah, this is actually, sorry, Your Honor, this is actually just our first pretrial. The previous one got continued.
Well, this is final pretrial according to the schedule order, so it's the first and final. So we have a trial date set, I believe, and all right, I want to go ahead and reschedule this suppression hearing just so that we'll have it ready in case the motion is not withdrawn. So, did you get the USB drive, Mr. King?
Your Honor, I just mailed that, so it just went out.
All right, when did you just mail it?
Put it in the mail yesterday, so whenever it got picked up.
All right. Okay, well, let's look at, why don't you do this, Mr. King? Why don't you go ahead and get another one and send it on out tomorrow, and then you can just replace what she said with that. And that way we won't have to run into any major delays with the mail coming from Cincinnati. All right, let's look at another hearing date then.
Last week for me, I don't have any trials scheduled, is the week of October 11th and 12th, 13th.
The 11th is a holiday.
Yeah, starting 12th.
See,
I think we have trials on the 12th and 14th.
yeah, on the 12th, let's see, Mr. Park led today. There's Murphy, Marika, Rhodes, and Sowers. All right, the 15th at 1 o'clock.
Okay, on a Friday?
Yeah.
That's fine.
Assume your criminalist was just not available on that particular date, there's not a problem with that person being out for like a period of time or something.
That's correct.
Okay. All right. Now, any other matters we need to discuss at this point?
No, sir.
A written plea offer was faxed this morning. Just want to put that on the record.
All right. Okay. All right, well, then, Mr. Van Ness, don't need to be here on the 29th. We'll send you an assignment notice, your attorney will as well, I'm sure. The hearing will be on October the 15th, that's Friday at 1 p.m.
Okay,
All right, thank you.
thank you, Your Honor.
All right, let's see, Brandon Abel. You're handling the Abel case?
That's correct, Your
All
Honor.
right, Mr. Ness, you can go ahead and log off as well as Mr. Gard, the police case.
She's on this case too. She's on Engel as
Oh,
well,
Mr. Gard's on Abel, I'm sorry.
but it's at 3:30.
All right. It's 3:30. Can you get a hold of your client, see if you can log in earlier?
I'll let them know now.
Thank you.
They responded, so they should log down shortly.
All right, thank you.
Recording stopped.
There we go.
Okay, I think we're there.
Recording in progress.
All right, Mr. Engel, if you would unmute yourself there. You push the button down in the corner, and there you go. Okay, it's case number 20-CR-156, State of Ohio versus Brandon Engel. This is a pre-trial being conducted by Zoom. And you are Brandon Engel?
Yes, sir.
All right. Mr. Engel's attorney, Alex Deardorff, is present by Zoom, as well as Assistant Prosecutor June Rader, representing the State of Ohio. Defendant charged with kidnapping and robbery. This is the first pre-trial, final pre-trial set for the 7th of October, and a jury trial set for November the 8th. So I see the state has provided discovery. Did you get that, Mr. Deardorff?
I did Monday, Your Honor.
All right, this is filed last Friday, wasn't that? All right.
It's a similar, sorry, Your Honor, there's a similar issue. I did mail out a USB for some of the digital items.
All right. Your discovery will be due by the final pre-trial on October the 7th. And I see you did file a motion to preserve audio and video. Were there any audio and video in this case, Mr. Rader?
I would have to go back, because obviously this is an order case that we kind of had to pull back out, and I do not have the physical file in front of me. I know it's been sent out, so honestly, I can just report to the court at this point. I don't believe, I am unaware as to the answer to that question, other than the fact that it has been sent out to her.
Okay.
So we'll have.
I'm looking at the discovery. I don't see anything referred to any. So
It was in the I read through the police reports and it said the victim interview was recorded twice.
Okay.
So that may be what, and they did put on there for me to send a USB, so they may have, that might be what's coming to me.
Yes, it's being put on a USB, Your Honor. Sorry, I just got a response from the office.
All right. Well, once we identify those that they're provided, then I'll take care of that. All right. Do you anticipate any other pre-trial motions, Ms. Engel?
No, Your
Ms.
Honor.
Deardorff?
No, Your Honor. That's it.
Now, they'll do a final pre-trial as well. All right. And has there been a written plea offer provided yet?
Yes, Mr. Mayor.
Yeah, it's been.
You have it, Ms. Deardorff?
I do.
Is your client aware of it?
We briefly discussed it, yes.
Okay. All right. All right. Any other matters then to discuss in this case?
No, sir.
All right. Then we'll be back on the 7th of October for the final pre-trial. We'll probably do that by Zoom as well. We're trying to conduct as many hearings locally as possible due to the pandemic.
If we have an agreement, Your Honor, would you like him present on that date to take care of it at the pretrial or set a plea date from the 7th?
We can do it on that day, yeah.
Okay, all right, thank you.
And right now, we're doing pleas remotely as well, as long as the defendant and counsel are agreeable.
Okay.
You know, Hyde County, well, we've got it throughout the jail and a bunch of our sheriff's departments have been, you know, our schools, and Hyde County's like the second, third highest rate in the state, so.
Okay.
You know, we're trying to do everything we can to avoid exposing other people, particularly other people from other counties, so.
Okay, thank you.
Thank you. All right.